Arbitration is not for every dispute, but every corporate counsel and business person needs to be thinking about it and before their dispute happens. Arbitration and litigation certainly have a number of similar characteristics, but I think that arbitration has features that are unique, that make it different than litigation and are particularly attractive to business people. The first of those is confidentiality. Courts are inherently public, and many businesses would like to have their disputes determined behind closed doors, whereas particularly where there's issues of confidentiality in terms of sensitive information or trade secrets. You're able to do that in arbitration the way that you can't necessarily do in litigation. The second reason is flexibility. You can really create a process that meets your needs, assuming you've got cooperative counsel, and I'm going to talk more about that in a minute. Third is you get to choose your adjudicator. There are many high-quality judges in Canada and Toronto, but I think that there's something to be said for being able to choose an adjudicator that has a particular technical expertise, or because of the parties involved, you may want somebody who's known to run a good hearing, and you actually get to choose that person, and I think that's a real benefit. The last is speed. Arbitrations typically take less time than litigation, and as a result, your business people can get back to business. Companies are and always have been sensitive to the cost of dispute resolution, and arbitration has always been sold as being less expensive. And those of us who practice in this field are sensitive to the fact that many companies are now saying, well, it hasn't been. So what I say to them is that you have to really decide what kind of process that you want, and to make use of the efficiencies available in the arbitration process to have an efficient hearing both from time and from cost. There's three things that I want to provide as tips to think about. Number one is document and oral discovery. We in litigation mass produce all of our documents, every document that has that may touch on a subject matter, and in turn that costs a lot of money. Most of the time most of those documents don't matter. In an arbitration, you can sit down and create a process with counsel about which documents really need to be produced, and only focus on those key documents. Think about that and think about whether or not you really need oral discovery, and if so, only on key issues. And you can reduce so much pre-arbitration, pre-hearing time. The second thing to consider is whether you need all witnesses to testify live on all issues at the hearing itself. So in traditional litigation, we have the witnesses attend and give their examination in chief and cross-examination, and that can take quite a bit of time. In arbitration, you may choose to do written witness statements for your evidence in chief, particularly for experts who can use their evidence in chief, or you do their evidence in chief just by filing reports. The third thing is to consider the use of time limits. Many arbitrators at the first procedural meeting will find out how long you think this hearing will take, and many of them will hold you to it. And one of the things to consider is whether you, with opposing counsel, can agree to time limits for every witness, so that you know exactly when your hearing is going to start and when it's going to stop, and a 2-week hearing actually is a 2-week hearing. And if you follow those steps, which are steps that I'm talking about in the context of ad hoc arbitrations, but are often done in international arbitrations and are pursuant to certain international rules, if you follow those steps, you can have a more time and therefore cost-efficient hearing. Quite simply, no. We have a really supportive court system in Canada and in Ontario that allows for the recognition of domestic and international arbitration awards. So you don't really have to worry so much about enforcement, generally speaking. In Ontario, we've adopted the UNCTRL model law, which allows you on application to the court to obtain both recognition and enforcement of your international award. And in Toronto, our commercial list, which are specialized commercial court judges, they'll hear those applications quite expeditiously. It's really hard to think of your divorce when you're in the process of getting married, but the reality is you need to be thinking about your dispute resolution clause when you're drafting your commercial contracts. Too often as arbitration counsel, we get brought into arbitration disputes and we find out there's a bare bones arbitration clause that somebody has thrown into the contract as an afterthought. Now that's not to say that when you give it a lot of thought, you're going to actually want a really detailed arbitration clause. There might be reasons why for you commercially that doesn't make sense, but you at least need to turn your mind to the idea of whether you want to put some meat on those bones. And when you do that, I suggest you think about 4 things. Number 1 is, are there disputes in this contract that I want arbitrated? And there may be disputes that you don't want arbitrated. So give us a clear jurisdiction clause. The second is, what law should govern this contract? And you can really choose any jurisdiction that meets your business or cultural needs. The third is, where do I want my arbitration held? The fact that you've chosen the governing law of one jurisdiction doesn't mean the seat of your arbitration needs to be there. So you may choose a country like Canada or a city like Toronto because of ease of access of the borders if it's an international contract, so that business people feel comfortable coming here. The last thing that you want to consider is, what are the procedural rules that are going to govern? So I've talked a lot about ad hoc arbitrations, but the reality is, on an international context, most of them happen pursuant to rules set by institutions. You should familiarize yourself with those rules and then choose a set of rules that make sense for you and your business. My top 3 tips really follow from what I've already said. So first, plan ahead. Think about dispute resolution as you're drafting your commercial contracts. The second is, once you're in it, choose your adjudicator carefully. It's one of the key benefits that you get with arbitration, and it shouldn't be one that's lost or rushed. You should think of what skill set you want in this individual that you think is going to benefit your client, being your internal client when you're corporate counsel, and will run a time and cost-efficient hearing. The third thing is to think about what you really want out of an arbitration. Do you want litigation style? Because you can do that in many ad hoc arbitrations for certain, and you can find counsel who are willing to do that for you. However, you may want something more efficient. You may want to take advantage of some of the efficiencies I've already talked about. So you want to carefully sit down with the arbitration counsel that you've chosen to discuss those options.